Ready? Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone, and good morning, Judge Rovner.
Morning.
Our first case for argument this morning is the United States against Andrew Johnston. Mr. Falvey.
Good morning, Your Honors. Joe Falvey for Appellant Andrew Johnston. May it please the Court. At great personal risk, Mr. Johnston took swift action to protect a government witness and then helped the government investigate and prosecute the prominent cartel leader responsible for threatening that witness's life. The government believed this deserved a sentence reduction of 25%, but the district court denied all but a fraction of that request, effectively sentencing Mr. Johnston to an additional 2 years in prison for only one reason, because Mr. Johnston had challenged his convictions, which the district court believed showed a continuing lack of remorse. This was wrong for at least 3 reasons. First, as cases like Purnell, Shannon, and others make clear, courts may not penalize defendants for challenging their convictions, even if those challenges prove frivolous or frustrating. Yet that's exactly what the district court did here by expressly basing its decision on Mr. Johnston's challenges. Second, the district court relied on only one isolated sentencing consideration to the exclusion of numerous others, contrary to this court's Chapman line of cases. And third, just as this court held in Harrington, the district court did not adequately explain its decision, as it never even attempted to explain how Mr. Johnston's challenges showed a continuing lack of remorse or how any other sentencing considerations affected its decisions. Stepping back for a moment to the jurisdictional issue that the court asked us to address, the parties agreed that the... Oh, sorry, Your Honor.
I'm sorry. But before you go any further, are you aware of a case that the Supreme Court issued yesterday?
I am, Your Honor. Yesterday afternoon, we submitted a 28J letter to the court regarding that case, Wilkins, Your Honor.
Right. Do you want to explain how it helps you?
Absolutely, Your Honor. As we set out in our letter, we do think it's quite helpful for at least 2 reasons. In Wilkins, the Supreme Court reiterated the longstanding rule under its modern precedent that only a clear congressional statement can establish a jurisdictional time limit. In addition, the court reiterated that when a time limit is separated in the statute from a jurisdictional grant, that's very strong evidence that the time limit is not jurisdictional. That essentially confirms this court's reasoning in Taylor, which relied on the fact that the only conceivably relevant statute in this case, Section 3582C in Title 18, is separated in the criminal code from the jurisdictional grant here. That separation is very strong evidence that the statutory provision relevant here is not jurisdictional.
Well, Wilkins involved sort of a pure statute of limitations, did it not?
It did, Your Honor, yes.
And there is a distinction between that and what we have here, which is a rule and a statute that exists to promote finality in sentencing pursuant to the Sentencing Reform Act, rather than private rights, as I sort of classify pure statutes of limitations. So we have public interests in play here in a way that is less obvious when we're dealing with just an ordinary garden variety statute of limitations, even for a statutorily created cause of action. Isn't there a distinction there in assessing the jurisdictional or non-jurisdictional character of this statute plus rule?
I think ultimately no, Your Honor, for at least 2 reasons. First, although this case doesn't involve a pure statutory limitations period, like you mentioned, the Supreme Court hasn't limited its modern precedent on the difference between jurisdictional rules and claim processing rules to the statute of limitations context. It's applied those rules across a variety of filing deadlines, and there's a filing deadline here. Second, Your Honor, you mentioned that this case implicates the public interest. I think that is true. That's why I think it's very significant that the government is in a position here to represent that the public interest would be served by not adhering to the filing deadline, by essentially waiving the filing deadline. So if the court is concerned about whether the public interest is adequately represented, I think the government is very well positioned to present those concerns to the court and ensure that the filing deadline here is not abused, or the possibility of waiver is not abused here, Your Honor.
Mr. Falvey, if we go and conclude claims processing rule versus jurisdictional, and we conclude waivable, how deep are we supposed to get into Chief Judge Pallmeyer's order? Chapman gives us a certain development of that, but Chapman cites McDowell. What are we to do with that?
Well, I think the district court's citation of McDowell on the merits is not critical. If this court agrees that it has jurisdiction, then I think the court should use Circuit Rule 40E to overrule McDowell with respect to jurisdictional issues, and then proceed to analyze whether the district court's decision should be upheld on the merits.
So you indicate that we should do a full review of what Chief Judge Pallmeyer said in her 2-page Rule 35 motion.
If so long as this court agrees that she had jurisdiction, I think the merits of her decision is subject to review by this court under 3742. The standard of review on the merits allows this court to review whether the district court failed to consider factors that it should have considered, whether the district court considered impermissible factors, and whether the district court adequately explained its decision. That's under Chapman, Harrington, other cases. So those are the issues that we're asking the court to review on the merits, so long as the court agrees that she had jurisdiction.
But that's a limited scope of review. We do not review the weight that Judge Pallmeyer assigned to these 5 cases that she concluded reflected a lack of remorse or a less than full acceptance of responsibility on the part of the defendant, and that seemed to be primary in her decision-making process. We don't second guess the weight she assigned those cases. We look for legal error, essentially.
That's correct, Your Honor. It's true that this court doesn't have jurisdiction to review the weight that the district court assigned to particular factors, or how the district court ultimately chose to balance a variety of factors. But what this court does have jurisdiction to review, and what we're arguing, is that the district court failed to consider factors that she should have, or considered impermissible factors. Under the Chapman line of cases, the court does have jurisdiction to review those issues.
It's kind of a fuzzy line, hard to walk in actual cases.
It can be fuzzy, I think, in some cases, Your Honor, because I understand the questions do have some degree of overlap. But in this case, I think we don't get into the fuzziness part of the rule. There's a clear impermissible factor that the decision below was based on, Mr. Johnson's challenges. Under Purnell and Shannon, the fact that Mr. Johnson had chosen to challenge his convictions is a flatly impermissible factor. Shannon emphasized that even a hint that would tend to discourage a defendant from raising a challenge to his sentence is not permissible. There's much more than a hint here. The district court, this is at RSA 2, the district court expressly relied on Mr. Johnson's challenges. That's an impermissible factor under Purnell and Shannon, and this court has jurisdiction to review that error. In addition to that...
So you're asking for a hard rule that any consideration of post-conviction, or not even post-conviction, during the course of the prosecution, litigation behavior that reflects a lack of remorse and has some connection to the criminal case is off limits. In other words, it's legal error to consider what Judge Pallmeyer considered. Not because of the weight she assigned to it, but it's just flat out legal error. No judge can consider litigation conduct.
I wouldn't phrase it as a hard rule, Your Honor.
We have to fit it into the category of legal error, just not impermissible weight, abuse of discretion. That's why I'm trying to mark the line.
Absolutely, Your Honor. I think the reason I say it wouldn't be a hard rule is because this would be a very different case if Chief Judge Pallmeyer had actually cited or quoted filings or statements in the recent litigation, post-litigation conduct that attest to lack of remorse. If this would be a very different case if she had identified recent filings where Mr. Johnson said, I don't feel remorse. I do not expect responsibility. But she did not do that.
Defendants rarely say things like that. They just make sometimes fantastical and groundless claims about their criminal cases, and that's what Judge Pallmeyer concluded was going on here.
I think
the suit against AT&T, the RICO suit for a vast conspiracy to frame him, etc.
Well, I think that may have been going through the district court's head, Your Honor, but at the end of the day, that's not in the decision below. All we have in the decision below is the district court citing the fact that a challenge was raised, and then a citation to very broad dockets without further description. I think is very telling, actually, Your Honor, that neither the government nor the district court has identified any statements in those filings or other filings of any sort indicating that Mr. Johnson actually does lack remorse. The AT&T suit and the RICO claims that you mentioned, Your Honor, I think actually help us. Because what was alleged there, what the government in his brief states was alleged there is that Mr. Johnson alleged that the sentencing judge and other government officials did not adequately assist him in serving his subpoenas, and that AT&T and other telecommunication providers violated his constitutional rights in a certain way.
I don't know that all 5 of those cases, though, fall into the category of being not being an attack on his previous conviction. Some of them may, but I don't know that all 5 do.
Well, that maybe you're not. I think at the end of the day, we don't know because the district court didn't identify that, and perhaps more importantly, the government doesn't. The government only identifies the AT&T suit and the suit against the judge, and I think it's clear from the government's description in its brief of those cases that they were not attesting to Mr. Johnson's lack of remorse. They were just asserting that constitutional or procedural rights were violated at some point during his prosecution, and certainly those claims were striking. They certainly may not ultimately have prevailed. But they do not support the district court's conclusion that Mr. Johnson lacks remorse. We could certainly speculate about what may have been going through the district court's head when it made its decision here, but all that was actually written down was the fact that Mr. Johnson had chosen to challenge his convictions, with a special emphasis on the fact that those challenges named the sentencing judge as a defendant. Under Shannon and Purnell, that's an impermissible factor, which we think warrants vacator here. I see, Your Honors, that I've reached my opening time. Would it be all right if I reserve the remainder of my time for rebuttal?
That's fine.
Thank you.
Thank you. Next up, I believe we have Mr. Murphy as appointed amicus.
Good morning, and may it please the court. A statute or rule does not have to incant magic words to be jurisdictional. It must merely make clear, using the traditional tools of statutory construction, that it has been imbued with jurisdictional consequences. Rule 35B fits that bill. But even if you disagree with me about the jurisdictional nature of Rule 35, the party's approach to waiver here doesn't work either. The government has taken the position that it can waive the one-year rule, and the appellant agrees, but neither has been able to point to a case in which a party is able to excuse its own noncompliance with a rule. That's because it doesn't make sense to think one can. And there are strong textual reasons to think that neither party can waive the rules requirements here.
Has the Supreme Court ever acknowledged a class of non-waivable claims processing rules?
I think that the Supreme Court has certainly acknowledged that there are categories of mandatory claim processing rules that are so emphatic that they prohibit things like equitable tolling. I don't think that they've acknowledged one that is on all fours with the rule we have here. I don't think that's problematic because the way that this rule is structured is sort of unique. I don't think there are many rules where the person moving is doing something for the benefit of the other party. And so I think the structure is kind of weird, but I don't think it's that problematic to say that there's not another case on all fours recognizing exactly this rule. And so, I can start with the waiver part, but I think maybe it makes the most sense to start with jurisdiction, since, obviously if it's jurisdictional, you can't waive anyway. So maybe start where Judge Rovner did with Wilkins. I think that, Wilkins doesn't break any new ground. I think that what Wilkins says is consistent with all of the other cases. And the main point is that the hallmark of a jurisdictional rule is that it talks about a court's power. So the statute of limitations in Wilkins is really directed at parties and their time to take an action. That's different than 3582 and Rule 35, which both talk about a court's power and a court's ability.
But I take it you would concede that the court in Wilkins certainly reiterated that a procedural requirement is only jurisdictional if Congress clearly states that it is. And, the further clarification, I'll quote, that traditional tools of statutory construction must plainly show that Congress imbued a procedural bar with jurisdictional consequences. So, in making that assessment, it seems that the court looked at the language and at whether the time limitation was in the jurisdictional section of the statute or a remote section. So all of those factors, if we apply them to the case here, would, it seems, favor treating it as a non-jurisdictional claim processing rule. So
I don't agree, Your
there we
Honor.
are.
I think that I certainly concede that there is a clear statement rule. I think that the things that Wilkins analyzed don't point in the same direction here. I think first and foremost, the statute of limitations, as Chief Judge Sykes alluded to earlier, is pointed at parties and not the court. So that's the most important factor here. I think that the larger statutory context here, the way that the sentencing statute is structured actually points the other direction as well. In general, district courts do not have the power to modify a sentence after it's been imposed. A sentence is a final judgment. And so the district court is going to need something to empower it to be able to modify that sentence. And Section 3582C(1)(b) tells us that it's Rule 35's requirements. And that makes, in this context, the statutory structure points in the direction of reading Rule 35's time limit as jurisdictional. And then the broader contextual point, sorry, Your Honor.
No, you finish.
And then I was just going to say, and then the final point is that context about placement in the U.S. Code is obviously one clue about whether provision is jurisdictional, but it's not dispositive. Mere placement is never going to tell you something. That's why, this court and the Supreme Court have both recognized that other time limits, like the one in Section 2107 and Rule 4 of the appellate rules, are jurisdictional, even though they appear outside of the general grant of jurisdiction in Sections 1291 and 1292. And so I think, while that's one clue, I think it's outweighed by the rest of the evidence here, which points towards a jurisdictional reading.
But I take it, well, okay, if we decide to hold that Rule 35B's time prescription is not jurisdictional, we will have to overrule our prior decision in United States versus McDowell. Would you agree with that?
I do think you would have to overrule McDowell to the point that it held that Rule 35B1 is jurisdictional. I think that portions of McDowell actually still support the secondary argument I've made, which is that the rule is structured in a way that it would not, in fact, allow the government to waive the time limit, and it wouldn't allow the defendant to do so either because of the way that the sentencing statute works and because of 35B2 and the way that 35B2 would be rendered surplusage. And so, I think that that's the main reason why it doesn't make sense to read Rule 35B1 as waivable, is because, the statute gives a district court authority to modify a sentence only to the extent that you have complied with Rule 35. That means that, in the absence of compliance, including with the 1-year requirement, a district court doesn't have the power to modify a sentence. And so, in some ways, the same evidence that points toward a jurisdictional reading, if you don't think it's jurisdictional, supports a reading that at least at a minimum says the district court isn't going to be able to grant that motion on the merits. And I think that's also why it doesn't make sense to think even here the defendant can waive, as you would have in the normal situation with a non-jurisdictional claim processing rule where the other party gets to waive or forfeit. And then the last point is the surplusage problem, which is that if you do read 35B1, and this is something that McDowell acknowledged, if you read 35B1 to be waivable, it essentially eats 35B2 out of the rule. And so you end up in a situation where you would never have 35B2 apply because the defendant could just always waive. And so you could have a motion to modify a sentence anytime. And that really undermines the finality interests that 3582 and 35B1 are trying to get at.
And your argument needs to contend with U.S. v. Taylor?
It does. And I don't think that Taylor's to the contrary. So I think that Taylor is really about a merit standard. It's about the elements, whether meeting the elements of one's claim can be treated as jurisdictional. And I think that for the reasons the court has said in things like Arbaugh or Gonzalez versus Thaler, it doesn't make sense to think of the essential elements of a party's claim as jurisdictional, because then you just collapse the jurisdictional inquiry and the merits inquiry into one. And so I don't think that the court or this court has ever held that that kind of essential elements standard is jurisdictional, but it has several times held that a time limit can be jurisdictional. And in Bowles, that was part of the Supreme Court's rationale to distinguish Arbaugh, is to say Arbaugh is really about a merit standard. It's not about a time limit. And so what we're talking about is a time limit. And then Gonzalez versus Thaler did the opposite, where it said, Bowles is really about a time limit, and this is about a merit standard. And so I actually think that Taylor was correct to hold that, whether or not you satisfy essentially the elements of your claim, it doesn't really make sense to treat that as jurisdictional. But that doesn't undermine treating a time limit as jurisdictional in the context of Section 3582 and Section 35B1.
Even if we understand Taylor as restricted to this eligibility limitation,
Right.
Not collapsing eligibility standards for a sentence modification with jurisdictional requirements, as you're arguing. I mean, there's some broad language in that opinion that would have to be massaged, I think, to get there.
Right.
But assuming that we are with you on that, even focusing on the time limit and the link between the rule and the statute gets us into Hamer's refinement of Bowles.
Right. And
Which talks, Hamer was all about another case from this circuit, and it's all about the intersection between statutes and rules for purposes of this jurisdictional claim processing analysis.
Right. I think that Hamer is consistent with my reading too, in the sense that in Hamer you had a time limit that was only contained in the federal rules, and it had no basis in the statute at all. And I think the difference here is the incorporation by reference that Congress made to Rule 35, which it amended to include a one-year requirement at the same time. And so I think reading 35B1's time limit here as jurisdictional is consistent with Hamer because it does have a statutory basis through the incorporation by reference. I see that my time has expired, so if there are no further questions, I'll take my seat. Thank you.
Thank you. Ms. Alexakis.
Good morning, and may it please the court. Georgia Alexakis representing the United States. This court should affirm the district court's order granting the defendant a 10% reduction in his sentence in exchange for his substantial assistance to the government. And I'd like to pick up where Mr. Murphy left off with respect to the question as to whether or not Rule 35B and the time limit encompassed in that rule, not the statute, and the rule represents a jurisdictional requirement versus a waivable claims processing rule. And here, the district court had the authority to adjudicate the government's motion for a sentence reduction precisely because Rule 35B is a waivable claims processing rule. Under post-McDowell Supreme Court cases, the courts must look for a clear statement from Congress that a rule or requirement, in fact, limits jurisdiction and thus triggers harsh consequences that flow from a jurisdictional requirement. Here, that harsh consequence being the dismissal of the government's Rule 35B motion, despite the defendant's substantial assistance. And here, I think this panel can rely significantly on Taylor in concluding that Rule 35B is a waivable claims processing rule. Taylor tells us that that 3582 as a whole, writ large, points out that it's not encompassed within the jurisdictional provision or the jurisdictional section of the criminal code. And the Supreme Court tells us that's an important important clue as to how we should read that time limit. Taylor also tells us that 3582C is not phrased in jurisdictional terms, and that is also.
But it is phrased in terms of the court's authority, the court's power.
It is, Judge, but the specific language in 3582 that talks about what a court may do versus what a court may not do is precisely the language in Taylor that this court pointed to and said it's not phrased in jurisdictional terms. And I think in particular, when you look at cases like Bowles and Hamer that look at time limits and look at the connection between the time limit in a rule versus the appearance of a time limit in a statute, I think combined with Taylor tells us that what we need to be looking for here is the time limit itself in the statute. I think Hamer is quite specific about that. It says that the circuit incorrectly decided Hamer in light of Bowles because the time limit that appears in Bowles, both in the rule and in the statute, in Hamer we have a situation where the time limit appeared just in the rule and not in the statute. And it's hard to walk away from those cases and not think that the appearance of that time limit, it's important to the Supreme Court that it actually manifest in the statute itself.
There's a stronger link between the statute and the rule here than there was in Hamer.
Because of Rule 35 being adopted as part of the Sentencing Reform Act. Am I understanding?
Well, it's cross-referenced on the face of the statute.
It is.
So it's even stronger. It's not just in the public law that, you can go and look up. It's right there on the face of the statute.
I agree, Judge. I mean, right. It specifically says Rule 35, but Rule 35 is more than just that time limit. Rule 35 encompasses Rule 35A, which requires, amongst other things, the presence of a clear error that needs to be corrected. And Rule 35B itself is, again, not just about that time limit. You need a government motion. You need substantial assistance on the part of the defendant. And when you look at 3582C generally, what you see are substantive limitations on a district court's ability to modify a sentence after the sentence has been imposed, but again, no express reference to a time limit. And so I think there's a way to read that statute and read it in sync with Bowles and Hamer, and to say, yes, 3582C does impose limitations on a district court's ability, but it doesn't mean that that doesn't make Rule 35B's time limit, it doesn't make it jurisdictional. It simply means that, yes, there is a time limit, and there are reasons for that 1-year mark that we see in Rule 35B1. But again, that doesn't mean that that time limit is jurisdictional.
These are all just basically eligibility requirements.
Correct. And if you look at the advisory committee notes, for example, for Rule 35, the committee was quite clear that one of the reasons for that 1-year marker is to incentivize prompt cooperation on the part of the defendant. We don't want a defendant sitting on a potentially critical piece of information and not sharing it until later. And so there are reasons that are separate and apart from a court's authority that explain why that 1-year limit would be there, and therefore bolster the argument that Rule 35B's time limit is meant to be a claims processing rule and was never intended to be a jurisdictional requirement.
But if you and Mr. Falvey are correct, what work does the exception to the 1-year time limit do?
Rule 35B2?
Right.
So I disagree respectfully with Mr. Murphy that there would be surplusage, because 35B1 and there are scenarios that Rule 35B2 doesn't cover that a waiver of the 1-year limitation in Rule 35B1 would. So Rule 35B1 contemplates scenarios in which a defendant obtains information within a year, shares it with the government, and the government can act. The utility, the value of that information is immediately apparent, as was the case here with Mr. Johnston. Rule 35B2 covers scenarios in which the information does not become apparent, or its utility or its value doesn't become apparent until after the year mark. What Rule 35B1 would still cover in a scenario in which the government could waive its time limit is a scenario in which the information is known within the year, its utility and its value is known within the year, but the cooperation is ongoing. The cooperation lasts longer than a year, which is not an uncommon scenario when you think about the length of many federal criminal investigations and the many layers that exist with respect to cooperation. It's not just a simple.
But when we talk about utility, if the 1-year time prescription in Rule 35B is not jurisdictional, does it really have any utility at all? Because look, in that scenario, the government could ignore the time period at will, couldn't it? because the defendant would never have a reason to challenge a late filing, since the defendant is the beneficiary of the filing.
So, Judge, I think that there is still a purpose behind that 1 year time limit, even if the government were able to waive that time limit. And the purpose is, again, to incentivize the defendant's prompt cooperation, because the defendant is running the risk that if he doesn't promptly alert law enforcement of information that he becomes aware of within that year mark, he runs the risk that he's not going to fall into one of the more narrow exceptions that are set out in Rule 35b2. And it also promotes, from the government standpoint, it gives the defendant an incentive to cooperate. It gives the defendant an expectation as to when he or she may be able to realize the tangible benefit of their substantial assistance. And it also gives the government a marker in terms of finality with respect to the sentence. It wouldn't be creating it wouldn't be creating an unlimited scenario, because from the government standpoint, certainly it can waive an oversight with respect to timeliness, but at the same time, it's doing so by weighing competing factors. And we've talked about this morning about the importance of the finality of judgment, the finality of the sentence. And so when the government is waiving timeliness with respect to its Rule 35b motion, it's doing so having weighed the importance of incentivizing cooperation versus the government's interest, frankly, the public's interest, everyone's interest in securing a final conviction. And so it's not clear to me that the government would always waive away its own error in not filing that motion within that year mark, whether it's an error or whether there were circumstances that necessitated the Rule 35b motion not being ripe for adjudication until after that 1 year mark.
Counsel, same question that I posed to Mr. Falvey with regard to the depth at which we are to examine Chief Judge Pallmeyer's decision. Under 3742, Chapman, these other cases, how far are we to go?
I think it's a pretty limited review. I think that the circuit has said that under 3742A, this court's review of Judge Pallmeyer's order is limited to determining whether or not Judge Pallmeyer committed a clear legal error. And here, there is no legal error.
Would that include the methodological approach that she used?
I think it would fairly encapsulate a review of her decision to impose a 10% sentence as opposed to a 25% sentence reduction based on the analysis of the 3553A factors. I think that this circuit's case law says that has left open the question as to whether or not a court is required to consider those 3553A factors. It has certainly suggested or made clear that a district court has the option of considering those 3553A factors. Here, Judge Pallmeyer opted for that. In fact, makes clear in a few different instances, the district court states that the court acknowledges that they are, quote, free to consider the 3553A factors. The court specifically references its earlier 3553A analysis that it had imposed 2 years prior, or that it had conducted 2 years prior when Mr. Johnson was originally sentenced. It's worth noting that the defendant never challenged that 3553A analysis on direct appeal as being either procedurally unsound or substantively unreasonable. And so to go back to your original question, Judge Brennan, where Judge Pallmeyer has acknowledged that the 3553A factors can be considered, and where Judge Pallmeyer then considers those 3553A factors, this court can review whether she committed legal error in doing so, but cannot consider whether, for example, she afforded undue weight to one factor versus another, as that goes to the district court's discretion.
What about the factors she listed of in the order itself of not accepting responsibility and citing the 5 cases?
That is not a legal error because Judge Pallmeyer was looking at Mr. Johnston's history of litigation activity, not to express frustration with him not as a way to personally retaliate against him. I think there's nothing in that order that can be fairly read that way. And instead, what Judge Pallmeyer is doing is continually referencing a lack of remorse and a lack of acceptance of responsibility. The court specifically says that the defendant has not yet acknowledged remorse, and defendant has not pointed to any statements that he has made in a pretty fulsome record, not just in this CR number, but across all types, manner of civil actions and appeals in which he has affirmatively expressed remorse. And so the district court was not did not derive an incorrect conclusion based off the record before the district court.
Isn't the challenge, though, counsel, that until he goes to trial in January of 2019, he's presumed to be innocent? So if some of these suits, for example, were completed prior to even his criminal trial, he's not in a position where he's deviating from his position of, I'm not guilty.
I think many of the suits, however, Judge, were filed after he was convicted. And in particular, like Johnston v. Ward was filed in 2020. That's the suit against the district court and her court reporter for allegedly tampering with the trial transcripts. Johnston v. Hoogland was also filed in 2020. That's the suit that the defendant filed against an FBI agent and the prosecutor in his most immediate case for allegedly submitting false documentation. And then you have, his most recent, in 2021, he filed an action under Section 2255 challenging the probable cause for his arrest, which is an issue that has come up not just on his direct appeal, but in numerous appeals that he has filed since then. And so I think the district court fairly pointed to these cases, identified the cases by name, and in that sort of shorthand way is saying that these are cases in which the defendant has not expressed remorse and in fact has done the opposite, which is to bring what this court itself has called frivolous claims challenging his conviction. And so there's no... Yes, Judge.
Forgive me, but by relying on this history of litigation to decrease a sentence reduction from 25% to 10%, is the district court essentially penalizing Johnson for exercising his right to appeal to the courts? Why wouldn't that be problematic?
I think it would be problematic if that's what the district court were doing. But I think what the district court here was doing, when you look at the order, is looking at that pattern of litigation activity and deriving from that a lack of remorse, a lack of acceptance of responsibility on the part of the defendant. In Purnell and Lewis, we have and I'm sorry if I see that my time is up, I'll wrap up quickly. In Purnell and Lewis, we have cases in which the court criticizes district judges for allowing their frustration to permeate the sentencing order. And I simply don't think that the district court's order here lends itself to that characterization. So unless there are further questions from the court, the government would again ask that this court affirm the district court's order in this matter. Thank you.
Mr. Falvey.
Just a few quick points in rebuttal, Your Honors. One on jurisdiction and a few on the merits. On jurisdiction, we agree with everything that the government said on jurisdiction and waiver. Taylor at 671, Chief Judge Sykes, as you pointed out, I think forecloses the amicus's position. Chief Judge Sykes, you pressed on the textual link, the link between the statute and the rule here. Two thoughts on that. That only matters if you conclude that the statute itself is jurisdictional. Because if the statute's non-jurisdictional, a link between a non-jurisdictional provision and a non-jurisdictional provision is not jurisdiction. So we think Taylor forecloses that possibility. Even setting that aside, if there is a link, the Supreme Court's decisions in Fort Bend and Arbaugh say that sort of link between discrete provisions is not sufficient to transform a non-jurisdictional provision into a jurisdictional one. On the merits, a few points in rebuttals, Your Honor. The government agrees that this court has jurisdiction to review errors of law, including methodological errors. That's what our three primary arguments raise. On opening, we focused on the fact that the district court relied on an impermissible factor, the fact that Mr. Johnson had chosen to challenge his convictions. The government responds that no frustration was involved in the decision below or annoyance. I disagree. I think the fact that the court went out of its way to emphasize that suits were filed against the judge herself may express some annoyance, but at the end of the day, that is not the critical aspect of our argument. The critical aspect of our argument is that a impermissible factor, Mr. Johnson's challenges, was a basis for the decision below.
Impermissible based on what source of law? What makes it impermissible? Is it due process? What's the thread of the legal argument that makes that impermissible? Because we have to focus on an error of law.
Of course. I think the short answer, Your Honor, is this court's precedent in Purnell and Shannon, which I think at the end of the day are rooted in due process concerns and the concern that defendants not be incentivized or deterred from challenging their convictions. This court in Burr emphasizes that anytime lack of remorse or someone's challenges are being considered in a sentencing context is very sensitive context. There's a very fine line between permissibly relying on a challenge and as opposed to punishing a defendant. Particularly given the sensitive context here, we think more was required of the district court. Even setting aside all that, though, we do have two additional merits arguments that are legally based. First, Judge Brennan, as you pointed out, the district court committed methodological error in its 3553 analysis because it focused, at best case scenario for the district court, it focused on one isolated post-sentencing development, Mr. Johnson's challenges, to the exclusion of others, including other post-sentencing developments, such as Mr. Johnson's spotless behavior record in prison, other rehabilitation efforts. So I believe the government agrees that in a case where the district court performs the 3553 analysis, at the very least, our position is that it needs to do so properly. And it can't properly do that analysis if it considers only one isolated post-sentencing development.
So what's the rule of law you're proposing?
The rule is that if the district court chooses to conduct a 3553A analysis, it needs to do so properly.
Meaning every 3553A factor? Some of them relevant ones, the ones that are raised by the parties? What's the legal rule?
I think the district court probably could rely on everything that happened before sentencing and the analysis of the sentencing considerations as it was performed at sentencing and not revisit all that. Certainly the district court should be free to do that because all of that's baked into the current sentence. What the district court should probably do is assess post-sentencing developments through the lens of the sentencing considerations as the parties present that sort of information to it. And the government mentioned that Mr. Johnson didn't present any information along those lines. He had no opportunity to do so. He had the time between the motion being filed and the district court's decision was just over a month, and he was not alerted that the district court was planning to conduct a sua sponte 353A analysis. I see I'm out of time. We would ask that the court vacate the decision below and remand for resentencing before a different judge. Thank you.
Thank you very much. Our thanks to all counsel, and a special thanks to Mr. Falvey and Mr. Murphy for accepting the appointments in this case to represent Mr. Johnston and to act as amicus for the court on these important questions. Thanks to your firms as well. Thank you. We'll take the case under advisement. Our second case this morning is Thomas Moore versus City of Chicago. Mr. Fox, whenever you're ready.
Good morning, may it please the court. This case is here from the grant of a summary judgment finding that there was probable cause to arrest, incarcerate, and prosecute the plaintiff for 7 years until he was acquitted in a criminal trial. The case is a Section 1983 wrongful detention case, and it's involving a robbery homicide that was committed by several black males and witnessed to some extent by 7 Hispanic persons. After plaintiff was identified in photo lineups and arrested, it became known that virtually every fact about the plaintiff that was discovered pointed away from him as the perpetrator. This included the fact that his nickname was Boomer. The perpetrator was known to be named Boom. This included the fact that the perpetrator was known to have a phone number associated with him. Not only did plaintiff not have a phone or that phone number, but that phone number continued being pinged after plaintiff by the detectives after the plaintiff was arrested. When Moore was arrested, which was just 15 hours after the murder, he was seen not to have a scratch on him. No injuries whatsoever. However, there had been a life and death struggle in the apartment where the murders occurred, and the victims, two of the victims, had bruising and marks all over him. Moore had nothing. The only specific characteristic descriptor of the perpetrator, other than being black male, was that this person was a huge or fat or 230 pound according to one witness, or 250 pound according to another witness person. Mr. Moore was not that person. He weighed roughly 185 pounds.
Well, it's not at all uncommon for eyewitnesses to guesstimate height and weight incorrectly. What's important here is that we've got 6 eyewitness identifications establishing probable cause. And the case law suggests that even one is enough. So we've got 6 here agreeing that Mr. Moore is the guy.
Sure. And there's a knee-jerk reaction to say, okay, there's all these eyewitness identifications, and therefore there's plenty of probable cause. But in the case of each individual eyewitness person, there were substantial reasons to doubt the reliability, because they either said things that they couldn't have seen because it was physically impossible, or they said things about the perpetrator that was impossible because they admitted that his face was completely covered, or they were coached. In one example, they were coached by the detectives to pick him out, according to that witness, to pick him out of the photo array.
What are we supposed to do, Mr. Fox, though, with the grand jury?
So what we do with the grand jury is that the evidence that was given to them was misinformed, much of it was omitted, and the ASAs that prosecuted the case didn't have a lot of the information at their disposal that should have been presented to the grand jury. So, for example, when I said that Mr. Moore didn't have a scratch on him when he was arrested, despite this life and death struggle, that information wasn't known to them, and so it wasn't made available to the grand jury.
But are we putting a beyond a reasonable doubt standard in instead of the probable cause standard at that juncture? Because clearly, obviously, he won a trial. So.
Right. But you know what? There was a lot of evidence. There was a lot of evidence that wasn't placed in front of the grand jury that the prosecutors didn't know about. Another example was the detectives went and interviewed for alibi witnesses. Mr. Moore had said, I was at a family party with my entire family. My girlfriend was there. I was with my girlfriend the entire time. The detectives went and talked to 2 sisters. The detective said those were the only witnesses to the prosecutors. But Mr. Moore had pleaded with the detectives to talk to his girlfriend. The detectives went to the house, were met by the girlfriend at the front door, knew that it was his girlfriend, and yet didn't talk to her. And that was notwithstanding that the 2 sisters said he was at this party, but they said there were holes in it because the 2 sisters said, well, we didn't see him 100% of the time at the party because I went upstairs sometimes to look after my children or something like that. So there was also the issue with the cell phone, which was not made known to the prosecutors. The cell phone, which was the most tangible piece, most important piece of tangible evidence in the case, because that was the information that had the name of the perpetrator plus the phone number, plus, according to Edwin Ramos, the perpetrator had been phoning and texting his brother, when it was his brother's cell phone, for the week prior. That piece of evidence was missing. The prosecutors couldn't know it was missing because the detectives never inventoried it. And it was never reported in a report that was missing. And so this was, again, some of the most important information in the trial. And there was more. There was more information that wasn't known. The initial perpetrator was identified as with the nickname Zebo. That came through over a call to a 911 call from the hospital. That information never made its way to the prosecutor.
Mr. Fox, forgive me. I'd like to go back, if you would.
Sure.
As Chief Judge Sykes noted, the prosecutor re-interviewed 6 eyewitnesses, as well as 2 alibi witnesses and reviewed the police reports before finding probable cause for the arrest. Why wouldn't that determination by the prosecutor, based on the prosecutor's independent assessment of the witnesses, break any causal connection between the defendants and the detention?
Because when you look at the facts about each individual witness, the prosecutor did not know, and I'll go through them. Delia Rivera, for example, she stated in statements and at the lineup that, yes, Moore was the one that had the gun that shot the victim. Miss Rivera was never in the apartment. She didn't know who shot the victim, and that's undisputed. And the prosecutor didn't know that. Alinda Kindelan, another witness, said in statements before the lineup, she said, I didn't see the perpetrator. She saw him outside. I didn't see anybody with a gun. At the courts of the lineup, she's quoted in the live lineup, she's quoted as saying, yes, he was the one with the gun. The prosecutor didn't know what was being said at the live lineup. Jacqueline Hernandez, another witness, she could barely give a description of the perpetrator, only saying he was a black male. Then she admitted to the detectives, as well as us in deposition, that his entire face was covered by a mask the entire time. So that couldn't be a reliable, not only could that not be a reliable identification, but she was asked to look at a photo ID, a photo lineup, I should say, at a time that it was impossible for her to have looked at one because of the timeline that went on. She was interviewed within 5 minutes of Edwin Ramos giving information about Mr. Moore, or Boom, I should say, because he didn't have Mr. Moore. And even the detectives say that wouldn't be time enough to make a photo array, assemble a photo array. Miguel, the witness Miguel, he was the one that said in statements to prosecutors before the lineups that he didn't see who shot the gun. At the physical lineup at which the prosecutors weren't present, he said, yes, that's the one who shot the gun. But he had said he didn't, the prosecutors weren't there to see that. And Edwin's testimony, Edwin Ramos, who was the main witness because he was the one that initiated somehow getting more into this photo array, which isn't known how it happened because there's no report of it. And the detectives all claim they don't remember how it happened. But Edwin Ramos testified that he was coached to pick more out of the lineup. And what his testimony was that he was shown a notebook full of photos. The detectives don't maintain notebooks full of photos. But in any case, he testified he was given a notebook full of photos. He picked one out. The detectives then went into another room. The detectives then came back with that photo in a photo array and said, so is this the guy you picked out? He says, yeah. And then they said, okay, sign under here and give it back to us. So he was coached to pick out Mr. Moore from a photo array. The prosecutors didn't have all this information. And so that's why you want to say they had a lot of eyewitnesses, but for each instance, every instance, there's a very real credibility and reliability issue. So, and
Mr. Fox, with regard to Mr. Moore's history here, were there a series of bail motions that were brought to try to, when this evidence started coming out with potential weaknesses, were there a series of bail motions that were brought to attempt to address his incarceration status prior to trial?
No, there weren't a series of bail motions that I'm aware of, I should say, in the criminal proceeding. And in fact, and then what happened even later on during the discovery process in the criminal proceeding, about a year later, the DNA evidence came back. Mr. Moore was excluded by virtue of the DNA evidence from being at the scene. So when you combine that with all the other evidence that they had, but the prosecutors didn't have all this other evidence, it was really plain at that point that there shouldn't have been probable cause to continue on with that proceeding. No DNA, all the factors about him were inconsistent with what was known about the perpetrator, and the witness all had reliability problems. And regarding the court's opinion and reliability, the court didn't analyze the case in terms of reliability, which it should, because that's the touchstone of probable cause. What it did was it continually said the plaintiffs had to show coercion, or it had to show that there was trickery going on. And we didn't have to show that, although we did with Edwin Ramos. We have to show that there was unreliability. And we did that in several different ways. And one thing that the court also did was, the court deemed as admitted, and it shouldn't have, but the court deemed as admitted all of the individual witness identifications in the Rule 56 Statement of Facts. The court deemed them admitted because we denied them based upon reliability and credibility. When the witness said in the statement of fact, yes, Alina picked Mr. Moore out of the lineup, we denied it, saying she couldn't have reliably and credibly done that because she said things that were impossible for her to know and inconsistent with other things. We said that for each and every witness. The court said that's not a valid denial, and then they deemed it all admitted. That deeming of that admission permeated the court's entire opinion so that it failed to look at the reliability of the witnesses throughout the opinion because of that. And a similar thing happened with regard to the expert witnesses. We had expert witnesses. The expert testimony was so skewed in plaintiff's favor that the defendants didn't even use their own experts, and we cited to the experts' opinions that we got from the deposition testimony. That's how skewed it was in plaintiff's favor.
But based on the constitutional standards for admissibility, not the test for probable cause.
So the court admitted that the opinions were admissible, and the court discussed that. They were in a footnote. They said it was admissible because the experts did more than talk about quote unquote a bottom line. There was no.
No, I'm not talking about the experts, the admissibility of the expert's opinion. I'm talking about the standards that you're arguing this case under. You seem to be filtering the probable cause inquiry through the Neal versus Biggers admissibility standard having to do with the reliability and suggestiveness of ID techniques. When the two things are separate, we said so in Phillips. We don't apply those suggestive ID standards to a probable cause determination.
Well,
especially in a hindsight civil suit for damages for false arrest or unlawful detention.
And I agree, the Phillips case is troubling because of that, and other things that it said. For example, it also said that the only way you can judge the reliability of an eyewitness is if he has a grudge against the perpetrator, but obviously that can't be true because there's other ways that a witness might be unreliable. For example, he might be talking about something it was impossible for him to see. And other cases post-Phillips, like Hart v. Menina, make reference to the 14th Amendment standards. So there is some inconsistency in the Seventh Circuit about using the 14th Amendment that comes after the Phillips case. And the fact of the matter is, we're talking about reliability. And the Phillips case was...
Actually, no. Probable cause is a reasonableness standard. If there's reasonable cause to support the arrests, then there's no Fourth Amendment violation. And so we don't do a robust reliability analysis in assessing whether there's probable cause to support an arrest or detention.
Well, I beg to disagree. In the Woods case, the court has said, the Seventh Circuit has said the touchstone of probable cause is reliability in the context of probable cause. And if you have evidence that's wholly unreliable and obviously unreliable, then it can't be relied upon to establish probable cause, because that's the...
What do we do in a case such as this, where you have Edwin, Hernandez, Miguel telling the detectives they were 100% certain of their identification? And when Walter was... who hadn't previously viewed the photo array, when he was called to view an in-person lineup, he said he was 80% sure, and the detective treated that as a negative identification.
Well... There was no evidence that there was 100% certainty by the witnesses. There was no contemporaneous reporting of it anywhere that there was 100% confidence in it. So all I can say is that's just not in the evidence that they were 100%. The 80% thing you mentioned about Walter was in the evidence, and I see that my time is up. So if it's okay with the court, I will reserve the rest of my time. Thank you.
Mr. Enriquez.
May it please the court. A grand jury indicted Moore when 7 eyewitnesses identified him as an assailant in the shooting. The sole claim at issue in this appeal is his Fourth Amendment claim against 12 detectives and the city for unlawful pretrial detention pursuant to legal process. The district court's grant of summary judgment in favor of the detectives in the city was correct for 3 independent reasons. First, prosecutors, not the detectives, were responsible for Moore's being detained following the grand jury's indictment. Second, the detectives had probable cause as a matter of law. And third, the detectives at a minimum were entitled to qualified immunity. First, prosecutors, not the detectives, were responsible for Moore's being detained following the indictment. Moore contends that he was unlawfully detained for the period of about 7 years between his indictment and the criminal trial. The indictment enabled the continued prosecution and detention of him until his criminal trial. Prosecutors have sole authority to seek grand jury indictments and otherwise prosecute criminal defendants. Police officers, including detectives, lack any authority to seek indictments or otherwise prosecute arrestees. Thus, whether probable cause exists to seek an indictment, and if an indictment is issued, whether to continue prosecuting a criminal defendant and to seek his continued detention, are decisions that can only be made by prosecutors, not police officers. Of course, prosecutors make those decisions based on the evidence, and typically they depend on police officers to inform them of the evidence. Thus, as this court observed in the Colbert case, while the state's attorney, not the police, prosecutes a criminal action, it is conceivable that a wrongful arrest could be the first step towards a malicious prosecution. But where a grand jury has returned an indictment, the chain of causation is broken by the indictment, absent either pressure or influence exerted by the police officers or knowing misstatements by the officers to the prosecutor. Here, Moore does not even contend that any detective pressured or exerted influence on any prosecutors, much less identify evidence to that effect. And while Moore asserts that a jury could be free to believe that the detectives made knowing misstatements to prosecutors, he identifies no evidence that any detective made any misstatement, let alone any knowing misstatement to any prosecutor. Thus, under Colbert, the grand jury's indictment of Moore, having been sought and pursued by prosecutors, not the detectives, broke any causal chain stemming from Moore's arrest and therefore precludes his unlawful detention claim. In his reply brief, Moore nonetheless says that various facts not found in the records that the detectives gave prosecutors were exculpatory, and he asserts that the detectives either did not or likely did not communicate those facts to the prosecutors, or that it could be inferred that they did not commute them to the prosecutors orally. Today, his counsel simply says they didn't communicate them to the prosecutors. But a claim that police officers withheld exculpatory evidence from prosecutors is a Brady claim, which is not a Fourth Amendment claim, but is a due process claim that lies only where the criminal defendant was convicted at a criminal trial that was unfair. Here, Moore was not convicted at his criminal trial and thus does not have a Brady claim. Regardless, Moore has no evidence that any exculpatory evidence was withheld from prosecutors. All 12 defendant detectives were deposed. Yet Moore does not identify any statement in any deposition to the effect that detectives did not tell prosecutors about any of the facts, including facts.
Mr. Enriquez, as to the cell phone that somehow disappeared after being seized as part of the investigation, was there any evidence known to law enforcement that the cell phone contained evidence exculpatory?
Absolutely not.
to
There's
Moorer?
no evidence at all that it obtained, that the cell phone contained any exculpatory evidence. Indeed, Moorer did not even, so as I said, all 12 detectives were deposed, yet Moorer has identified not a single bit of evidence that in any of those depositions that about what the detectives either told the prosecutors or did not tell the prosecutors about this case. Indeed, Moorer did not even ask any deponent what the detectives did. He didn't even ask them, any of the detectives, what they did or did not tell prosecutors. And notably, the record does not include the deposition of even one prosecutor who had any role in Moorer's criminal case before the grand jury issued its indictment or during the first 6 years after that he was detained after the indictment. Moorer asserts that a jury...
Is there any evidence that Mr. Moorer was on the defendant's radar as a possible suspect prior to his identification by Edwin from among the persons with a nickname that is similar to Boomer?
Absolutely not, Your Honor. The first inkling that they had about Moorer was when when Edwin, the brother of the murder victim, said that he had seen, he recognized Moorer during the incident at the apartment in which the shooting occurred, that he knew that he thought his name was Boom, and then the detectives went to their software using nicknames and learned, and that software produced over 100 names of people with the nickname Boom or various or variations of Boom, then showed Edwin that compendium of photographs, and out of all those photographs, and Moorer admits that there were more than 100 of them, Edwin identified Moorer from his photograph as one of the assailants.
So it's a known assailant identified by an eyewitness within hours of the shooting.
Within a very few hours of the shooting, that's correct. And then, of course, after Edwin identified the Moorer from his photograph, the officers created a photo array in which Moorer's photograph and the photographs of five other people were put on a five of the other people who were actually identified from were put on a photo array and shown to Edwin. Edwin then identified Moorer again, and then four of the other people who were present were shown that same photo array independently. They were separated in rooms. Each was shown the same photo array. All of them identified Moorer from the photo in the photo array. And then, of course, at that point, Moorer was eventually arrested based on a request to pick him up. And when he came in, there was independent lineups, in-person lineups, and eventually all 7 of the eyewitnesses independently saw him in an independent lineup and picked him out of the independent lineup.
And is Mr. Enriquez, is Mr. Fox correct when he states that Edwin Hernandez and Miguel did not tell the detectives, or that's not in the evidence, that they told the detectives that they were 100% certain of their identification?
The record is actually that one of the officers who interviewed several of the witnesses interviewed the ones who said they were 100% sure. His report says the interviewees, the eyewitnesses whom he interviewed, did say 100% sure. Other detectives interviewed other of the eyewitnesses. They didn't say the percentage of confidence that any of the others had, but there's no evidence that any of the others had less than full confidence in their eyewitness identification.
Well, other than Walter, who said he was only 80% sure.
Well, I'm talking, actually, I'm sorry, Your Honor, I should have qualified that. The photo arrays, five people looked at the photo arrays. All of them recognized Moorer, and eventually Walter, who had not seen the photo arrays, saw an in-person lineup. He was the only one of the 7 who saw the in-person lineup who said that he was less than 100% sure. He said he was 80% sure. None of the others expressed any uncertainty at all, no degree of uncertainty about whether or not they recognized him in the in-person lineup. So again, the grand jury's indictment of Moorer, since no evidence from any detective indicates that any of them failed to tell any prosecutor about any fact, exculpatory or not, and then there was not even a single prosecutor who was deposed in this case, and none of them provided any evidence that they were not told any of the facts that Mr. Fox says that prosecutors did not know. He's simply incorrect about in asserting that there were things the prosecutor did not know. He has the burden of proving his case on summary judgment. He has to prove at least deduce evidence on every one of the elements of his case. He doesn't have any evidence at all that that any information was withheld, nor of course did he have any evidence that any of the detectives lied to any of the prosecutors. And of course, there's no evidence at all that there was any impermissible influence or exerted over any of the prosecutors. Under the Colbert case, the chain of causation from the arrest was broken by the grand jury indictment. It was the responsibility, any responsibility for Moorer's detention after the grand jury indictment was the responsibility of the prosecutors, not the police officers in this case. I see I have very little time, but I do want to make it clear that there's also, not surprisingly, with 7 eyewitness identifications in the case, probable cause existed as a matter of law. Mr. Fox tries to indicate that some of those identifications were less than reliable. They're not. He says that there were certain things that were impossible for witnesses to know that they testified to, but if that doesn't undermine their reliability. The key thing that about those witnesses is that they testified to things that they saw Moorer doing, but they didn't have any doubt. They didn't say, there was no question about whether or not they identified him from his face, and the mask clearly came down during the incident for all of them except one of them. We acknowledge that Jacqueline Hernandez, who was in the car with Walter for part of the time, never saw the face of Mr. Moorer. All the others testified that his mask came down, they saw his face, and so there was no question about Mr. Fox's statement about that some witnesses testified to things they couldn't know is simply incorrect. If there are no further questions.
Thank you.
We ask that the court affirm the judgment of the district court. Thank you.
Thank you. Mr. Fox, I believe your time had expired. You may have an additional 2 minutes to rebut.
Thank you. With regard to the question of whether there were reports that said that the witnesses were 100% certain, they made a statement of fact at number 68 saying that these three witnesses were 100% certain. They didn't cite to any reports. They cited to depositions that were taken years later. It's not in any report. Detective Gonzalez did all the live lineups. He did a separate report for each one. There's not an indication of percentage confidence in any one of those reports, and that's all in our paperwork. As far as Edwin knowing the perpetrator before and being the witness, Edwin was wrong about everything that he said about the perpetrator. Edwin said the perpetrator's name was Boom, but it wasn't Boom. Mr. Moore's name is Boomer. Edwin had the phone number that was associated with Boom. That phone number was not Mr. Moore's phone, and in fact, that phone continued being pinged subsequently for months later after the arrest. Edwin said for somebody that he knew that Mr. Moore weighed 250 pounds. Mr. Moore weighed about 180. The real Mr. Moore weighed about 185 pounds, and we can reasonably infer that if Edwin really knew him, then his assessment of the weight would probably be accurate, but Mr. Moore did not have that weight, so everything he said was incorrect. Further, with regard to counsel's rendition of how the identification took place and that they looked up nicknames in the computer, went to software, and they produced 100 names, that entire thing is a fiction. Every detective that testified, and I did all the depositions, every detective that testified did not remember how it happened. They did not remember how it happened. There is no report about how it happened anywhere. Detective Gonzalez testified about it at a suppression hearing at the criminal trial, and in a very limited sense, he didn't give all the specifics. He said, "Oh, we went to a computer and did a nickname search." When he was asked about it, and that's all he said at the suppression hearing, not about getting 100 names and Edwin looking through them all. When he was asked about it at his deposition, he said he didn't really know about it. He didn't know who did the search. He didn't know about Edwin, about how many of the names it produced, and he didn't know what Edwin did in connection with that. And in fact, we did computer searches. And this is all in our additional facts. We did computer searches for this computer printout that they allegedly did. It doesn't exist. As far as counsel saying that I'll just give one example now. As far as counsel saying, if I could just.
You can finish up.
Okay. Saying that there was no misstatements by any of the detectives to the ASA. I just told you about one, and it's in the record. It's even in their brief. Mr. McDermott said there were just only the two sisters were the only alibi witnesses, when they knew there were many more witnesses because Mr. Moore had told them, and it's quoted in my brief that he said there were many more witnesses other than the two sisters. So that alone is one of many misstatements. Thank you.
All right, thank you very much. Our thanks to all counsel. The case is taken under advisement, and the court will take a brief recess before we call the third case this morning. All right, thank you, everyone. Our next case this morning is Donald Kinsella versus Baker Hughes. Mr. Coffey.
May it please the court. Good morning, Your Honors. My name is Tim. My name is Tim Coffey, and along with co-counsel Chris Kelleher, we represent the appellant in this matter, Donald Kinsella. I thank you in advance for your time and thoughtful consideration of the issues in this case. This matter comes before Your Honors for a review of the district court's denial of Mr. Kinsella's motion to vacate, in part, the arbitration award. Specifically, Mr. Kinsella moved to vacate the denial of his Americans with Disabilities Act failure to accommodate claim. I will address the merits of the appeal. My co-counsel, Mr. Kelleher, will speak to the appellee's motion for sanctions that they filed.
Before you get into the merits, would you address the question of jurisdiction?
I believe this court has jurisdiction, and the district court had jurisdiction by virtue of the filing of the complaint initially in the district court. The complaint always was maintained and pending in the district court.
Well, it was dismissed and then reinstated, as I understand the record. It wasn't, the lawsuit wasn't stayed pending arbitration. It was initially stayed, and then there was a dismissal and then a reinstatement. Isn't that what happened here?
I don't believe there was a dismissal of the lawsuit until after the court ruled on the motion denying my motion to vacate. The court ruled on that, and then a few months later, the court entered a final and appealable order. But I don't believe Mr. Kinsella's underlying lawsuit was ever dismissed. No, it was always pending before Judge Gettleman.
October 20, this is the red brief page, statement of jurisdiction, so page 1. On October 29th, 2021, the district court dismissed the action without prejudice and with leave to reinstate. So it was a dismissal, right? R46.
I'm sorry, you are absolutely correct. And then I moved to reinstate, which was granted by the court.
Right, but how does that solve the problem under the Badgerow case?
I'm not familiar with the case, Your Honor. I'm very sorry. We didn't anticipate a jurisdictional issue. None was briefed. None was raised.
Well, we have to address
I
jurisdiction.
understand. I certainly understand you do. My view on it was once the case was reinstated and the judge went on to entertain a rule on the motion to vacate, that it retook jurisdiction of the case.
Well, we're here on an order denying Section 10 motion to vacate the arbitration award. Is that right?
Yes, we are.
And the Badgerow case says that federal courts have no jurisdiction over those motions or actions or applications unless on the face of the application itself there's a basis for federal jurisdiction. There's no look-through to the underlying dispute. It's essentially a state law contract dispute about whether the arbitrator exceeded the authority granted to him or her by the contract for arbitration. And so those cases belong in state court. There's no look-through as there would be for a motion to compel or a petition to compel arbitration.
Look through the ADA, yes.
Right. So we can't rely on the underlying ADA.
I understand.
Look-through.
Section 10A4 of the FAA specifically states that the court would have jurisdiction.
No, it doesn't. There is no independent source of jurisdiction in the Arbitration Act. That's the whole point of the Badgerow case. There needs to be an independent basis in diversity jurisdiction on the face of the application or some federal law basis on the face of the application, not the underlying cause of action.
Okay. Well, I guess I would respond that there would be diversity between the parties in this case. So if it wasn't
Is there
spelled
diversity
out,
of citizenship?
I believe so, yes. Mr. Kinsella is Illinois, our defendants are Texas.
Okay. We may need some further briefing on the jurisdictional question here.
Yes.
Okay.
Okay.
You can go ahead on the merits.
This is a case.
Might I start you out, please?
Yes, please.
Thank you. Because, you argued in the briefs that the parties didn't merely submit a blank slate, but a narrow claim that was to be decided based on specific elements, including whether the defendant failed to provide a reasonable accommodation. But isn't it pretty well established in our ADA cases that a determination of that element often turns on the issue as to the parties' engagement in the interactive process? So what my question is how could it be improper for the arbitrator to consider that?
I would just say that the elements submitted by the parties, agreed to and submitted by the parties for the failure to accommodate claim did not include good faith or any other type of compliance with the interactive process. The interactive process, I believe, my opinion on the interactive process is the goal is to identify whether a reasonable accommodation exists. In this case, the parties went through an interactive process, and in fact, the accommodation was identified. So the open position was identified here. At that point in time, since we did prove that he was qualified and we proved the other elements that were submitted by agreement, at that point in time, when that position is identified as open and available, it is incumbent and a duty on the employer to appoint and reassign. So I don't believe any of the interactive process that was brought up by the court, first of all, it's not an element of proof, and second of all, it was unnecessary to the discussion. I mean,
Isn't this a discussion or an argument, though, with regard to the merits? We're here to the extent there is jurisdiction, we're here on a very limited review. The statute really prescribes only very certain circumstances where an arbitration award can be considered.
yeah, well, it exceeds authority is one of them. Arbitrators have authority to decide only the issues actually submitted to them by the parties. That's a quote from AGCO Court versus Anglin. There's no doubt here that he received the issues 3 times from the parties, all agreed, 5 elements to prove, and he added 2. And he did it post-hearing. He added 2 elements. He added 2 issues.
That's an argument that the arbitrator used the wrong legal standard. That's not a question of whether the arbitrator exceeded his authority.
Well, he got the legal standard from the parties. That's all his authority is. He doesn't have authority to add to
No,
it.
the authority in the arbitration agreement.
Yeah. The claims submitted by the parties. Parties submitted one claim, one FTA claim, failure to accommodate claim, 3 times to him with the same elements. And those are those section 4.03 jury instruction, pattern jury instructions elements for the failure to accommodate claim. And he went ahead and exceeded that and surpassed that.
That's not a question of exceeding authority. That's a question of applying a different legal standard to decide the failure to accommodate claim.
I think it's both in this case, Your Honor. I respectfully disagree.
Well,
I think it's both.
otherwise, every motion to vacate where there's a claim of legal error would come in the door.
Wouldn't we be reined in with these motions that Chief Judge Sykes is talking about?
I think in every case where the parties say, here is the issue, this is what we agree on you deciding. If the arbitrator goes beyond that and adds legal elements that are not in that issue that's agreed to by the parties, then yeah, I think the person exceeded their authority. I don't know.
I do not understand how you can fault the arbitrator for applying proper ADA law, even if the parties fail to identify it to the arbitrator. And, I don't know.
I don't. Well, I'm pretty confident that in this circuit, there's no discriminatory intent element to a failure to accommodate claim, and there's no but-for causation element to a failure to accommodate claim. I don't think that's disputed by anybody. So those 2 elements are not in the claim. The elements that are in the claim, the 5 elements, I was at the hearing, we proved him inside out. He added 2 elements to the claim.
That's a claim of legal error.
I think when the parties tell him these are the elements.
You
Sorry.
have to keep in mind how narrow, how very narrow our review of arbitration awards is to begin with. And, you can't, it just isn't sufficient to demonstrate that an arbitrator's award contained error of law or fact, if indeed it did.
I respectfully believe we've demonstrated more. I point to Edstrom Industries, E-Companion Life. I've seen no difference, and I suggest there's no difference between parties saying apply Wisconsin law and the arbitrator applying New York law to this situation. I don't see any difference between an arbitrator is not free to think or say the contract says X, but my view, I'm going to apply Y. That's from Chicago Typographical Union number 16. So I believe that law supports this appeal and would support Your Honor's reversal of the decision. I see I'm almost out of time.
All right. Thank you. If you're
Okay.
concluded.
Mr. Keller was going to briefly address the motion for sanctions.
That's fine.
Okay. Thank you very much.
Thank you.
Thank you.
Yeah.
Mr. Rowland. I'm sorry. We'll go to sanctions first, and then Mr. Rowland, and he can talk about both issues.
Good morning, Your Honors. Rule 38 sanctions are a hammer, but Baker Hughes wields it like a fly swatter. This is not an extreme case. There was no bad faith here. My colleague and I pledged to Mr. Kinsella to pursue justice for him as far as we conceivably could. We believe we have done so. Your Honors, we certainly recognize we have an uphill battle. The odds are against us, and the pathway to victory here is narrow given the court's review of arbitrator decisions. However, the facts remain that there are cases that we believe, specifically Edstrom and Chicago Typographical Union, that we believe our case fits into that rubric. The purpose here of Baker Hughes' motion is twofold. First, is a scare tactic to attempt to stymie Mr. Kinsella from pursuing his appellate rights. And secondly, to cast a cloud of impropriety over the appeal's merits. We respectfully suggest these are improper reasons under Rule 38. We would also ask the court to consider the precedential impact of a sanctions finding here, and that would be to chill appellate rights. It would also be used as a cudgel at the circuit mediation conferences by appellees. So we would respectfully assert that the reasons here again are improper, that we have pursued in good faith these arguments. And the precedent that typically in which this court finds sanctions involve unprofessional conduct by attorneys or instances where attorneys are disregarding controlling authority, and we respectfully assert there's no such situation here. Again, we've pursued these arguments, these issues, we've done it in good faith, and sanctions here should be applied sparingly, and this situation is not one where it's warranted. And we respectfully ask that the motion be denied. And if there are no further questions, thank you for your time, Your Honors.
Thank you. All right, now Mr. Rowland.
Good morning, and may it please the court. This is a very, very straightforward case involving an appeal of, essentially an appeal of an arbitrator's decision by way of a motion to vacate. Those decisions are not appealable in any way, shape, or form. That's the whole point of having arbitration, is to allow for finality and for that decision to hold. This court has repeatedly indicated that you cannot claim it to be, an arbitrator abusing authority, but really you're challenging the law. So this is like exactly on this.
Forgive me, but what do you think that we could consider a case? Well, okay. Do you think we consider whether an arbitrator's application of law was so egregious as to constitute arbitrary action? Could we do that, in your view? I mean, I know, you argue, of course, that an arbitrator's award will be enforced, even if it contains a serious error of law. But would you agree that we could consider whether the arbitrator's application of law is just so egregious as to constitute action that can be viewed as totally arbitrary?
Well, I think the line is drawn in this circuit where, so for example, in the Edstrom case where everyone agreed or the parties submitted and the agreement provided for the application of Wisconsin law, and the arbitrator didn't do that. And so in this case, for example, if the arbitrator had said, well, this is not the ADA case, this is a ADEA case or an FLSA case, and applied those kind of standards, there'd be review here, because that goes beyond the authority of the arbitrator to interpret an agreement that provides for jurisdiction over the case itself. So
Right.
It's just squarely within the line of cases that hold that even serious gross error is not sufficient to overturn an arbitrator's award as long as he was diligently, conscientiously applying the law, which he did here. This was no small endeavor by this arbitrator. The final judgment was order number 25 in his process, and so he was very diligent, very careful, and the opinion itself is very careful and very considered. Maybe some of the headlights were in the footnotes, but that doesn't change the analysis that he took the ADA, consciously applied it. And the argument that he somehow had to use the pattern jury instructions to decide the case, pattern jury instructions are not in the arbitration agreement, just the federal statutes. And frankly, even assuming they governed, the last standard of in the pattern jury instructions 403, defendant failed to provide plaintiff with a reasonable accommodation. That's exactly what he examined. Was there a failure to accommodate? How do you do that? Well, this court has prescribed that reviewing the interactive process to determine where the breakdown was is the most common way you're going to find whether the reasonable accommodation was or wasn't granted appropriately. So in this case, the arbitrator assigned blame to both parties. It said it broke down. It was a fault of Mr. Kinsella. It was a fault of Baker Hughes, and so therefore couldn't decide against Baker Hughes because it was not the sole reason for the hang-up of the reasonable accommodation process.
Before you get deeper into your argument about the merits and the scope of our review and then your sanctions motion, would you please address the subject of jurisdiction under Badgerow?
Yes. So Badgerow obviously is the operative case. And frankly, before Badgerow, this court had already decided the very same issue and indicated that there's no look-through in Section 10 of the Arbitration Act. Badgerow, like all the other cases I could find, involved a petition to arbitrate that was then arbitrated, and there was a new case that was filed, a separate petition after an arbitration concluded. Here, the district court retained jurisdiction by following a stay for, I think, 3 years, and then learning that the arbitration hearing had occurred, dismissed without prejudice with leave to reinstate. And I can't find a case where Badgerow or this court's prior rulings decided that was not retaining jurisdiction and that required a new petition or on its face for the motion to vacate to show jurisdiction. So I'm not sure exactly how it's different if a court stays in action or dismisses it without prejudice, with leave to refile. And the district court clearly anticipated that there might be a motion to vacate by providing for 7 days for the party to come back and say, here's what happened.
Yeah, I think it's the dismissal that is potentially problematic here because the Arbitration Act does permit a stay pending arbitration once a motion to compel arbitration is granted. And so that's not jurisdictionally improper because the case comes into federal court on a federal claim with federal question jurisdiction. But here the suit was dismissed and then reinstated, and we've got a case that says that's sort of the functional equivalent of, that sort of administrative dismissal is the functional equivalent of a stay, and so doesn't oust the original jurisdiction. Pre-Badgerow, I think we have to rethink all of this after Badgerow confirmed that there's no look-through, which we had held before. And then if there's an independent basis on the face of the motion to vacate in the form of diversity jurisdiction, we should know about that.
There are elements of diversity here, as Mr. Kinsella's counsel indicated. But I really don't want to give up on the point that Badgerow really doesn't apply here, because the dismissal without prejudice is exactly that. And in other contexts, including settlements, the district courts have been allowed to, retain jurisdiction essentially over a settlement because they, in the judgment and the dismissal without prejudice, explicitly indicate that it's subject to this, reinstatement. So
I think only if there's a consent decree.
no, actually, there are cases that do it outside the consent decree process. So it's not favored. I can't say that it's favored by this court, but there is a line of authority that provides for a settlement in the settlement process for the court to retain jurisdiction in a number of different ways.
In the Arbitration Act context?
No, it's this. I'm
okay,
just
that's
equating.
yeah,
I'm equating it because I don't understand what the difference would be if, in fact, that's the rule in settlement agreements. Why it wouldn't apply here?
It's because it's the text of the Arbitration Act that forecloses any jurisdiction, any look-through jurisdiction in Section 9 and 10 motions or petitions.
But we're not
based on the text of Section 9 and 10 as distinct from Section 4.
I guess the Arbitration Act, the Badgerow case talks about whether to look through or whether you can look through. Unanimously decided you cannot. But that presumes that the district court, no longer has jurisdiction and is being asked to retain, open it again. And here, it's a dismissal without prejudice, which I think jurisdictionally is also non-appealable, like a stay. And so I'm not sure why it is that...
Well, it's a dismissal. It just permits refiling, but that just begs the question about whether the refiling or reinstatement of the original suit has a jurisdictional basis consistent with Badgerow for purposes of entertaining a Section 10 motion to vacate.
Yes, I understand the point, Your Honor. I really do. I just think...
In your red brief, on your footnote 3, you reference Badgerow. You say, alternatively, to the extent that Badgerow applies, district court of jurisdiction under 1331.
Yes.
What's your position with regard to that now? This, Mr. Coffey's raised diversity. Looks like in your brief you're talking federal question.
Mm-hmm. The Arbitration Act itself is a federal question.
No, that's what Badgerow
answered
in the negative, and prior to that, the Vader case.
So I really do think here, if you agree with the analysis that Badgerow applies and this dismissal actually divested the district court of jurisdiction over the action, then there is diversity. Now, that it's plain in the pleadings that that's the case. It wasn't in the motion to compel itself, which is why this is such a strange circumstance to be applying Badgerow in the context of a case that was stayed and then at the very end dismissed without prejudice. Because it's just a motion to compel or a motion to vacate here is presumes the case is alive because there's no pleading. It's not a complaint where the plaintiff would then identify diversity or any other form of jurisdiction.
I think we're going to need a briefing on this.
I do too.
We'll issue an order after argument.
Okay. I kind
Okay.
of expected this might come.
Okay,
Sure.
you can pick up where you left off.
Yeah, thank you. So back to my argument on the merits, obviously, the district court did his level best, the arbitrator did his level best to decide the issue under the ADA, which is the operative statute. He had no obligation to follow the pattern instructions. That was just a guidepost for the arbitrator. There's nothing in the agreement that says you must apply pattern jury instructions in a arbitration proceeding. And in any event, the real question before the arbitrator was there a failure to accommodate, which is exactly what he had analyzed. He determined there was a breakdown in the interactive process, which is the normal way in which courts look at the reasonable accommodation process. And the fact that throughout the proceeding, respondents were making the argument that Mr. Kinsella had not followed the basic elements of trying to be considered for an accommodation, simply failed in that effort altogether. And so the arbitrator very clearly and carefully indicated that you're not qualified if you don't get analyzed by the person who can determine your qualifications. And so why would the arbitrator have to do anything else other than determine the person's not qualified and there was no failure of accommodation if in fact the individual plaintiff in that case or complainant in arbitration didn't take the appropriate steps to even get that process moving. And so if that's the case, there was a breakdown in the interactive process. There was some fault on respondents / appellees here by sort of failing to recognize that an application had come in. It was a confusion between systems that the Baker Hughes had at the time for hiring and replacement. So yeah, sure, there was some fault on both sides, and that's exactly what the arbitrator determined. In light of that, it's not appropriate to hold defendant liable for failing to accommodate, when in fact what it did was determine that it's equally shared burden and equally shared problem in this case where it just didn't have any. And so the appropriate outcome was reached, which was that there was no failure to accommodate. So I guess
Do you want to talk about the
Sorry.
sanctions? Do you want to talk about sanctions?
Sure. For the very same reason that this case sits in that paradigm of challenging arbitral authority by way of, really challenging legal error by way of arbitral authority, the cases are so clear, this court wouldn't be weighing in for the first time to grant sanctions for this repetitive behavior in this court and in the district courts, where you just can't use the guise of arbitral authority to challenge what he's challenging is a legal error. And in this case, that's more obvious than normal because right after the decision was issued, Mr. Kinsella went to the arbitrator and said this was clear error. When he went to the district court, even in the opening effort to reinstate, he also indicated that there was plain legal error. And as the district court here recognized, that's exactly what he's arguing, that there's elements were put in that shouldn't be in, that he misanalyzed this. We disagree that the judge or the arbitrator actually considered those elements in the reasonable accommodation claim, mentioned them. There's no setup of here are the standards, you didn't meet these two last factors that I've somehow created in a reasonable accommodation context. So it's just right down the alley of what this court has said parties should not do. They should not bring the action in the district court, and they certainly should not bring it here. We tried to impress upon plaintiff's counsel that this was an inappropriate treatment of the cases and inappropriate to bring the motion to vacate in the district court. We sent a Rule 11 letter explaining why this fits into the paradigm of all the other cases, and we cited them in that letter about why this is a sanctionable conduct on their part. And so that's why we're here. That's why we're seeking sanctions.
All right, thank you very much. Mr. Coffey, I believe you had a little time left for rebuttal.
May it please the court. In the few seconds I have left, Edstrom is on point, Your Honors. It is on point, and this is Edstrom, okay? It has not been distinguished at all by council. It supports this motion. And there's nothing sanctionable about this motion. We moved under the FAA, a specific provision there, A4, 10A4, and Edstrom supports this case and is highly persuasive, we believe, and has not been touched. Council's not made an attempt to distinguish it. There's no duty to apply, or, yes, there were legal errors here, sure, but that's not why we're here. So we're not here because of legal errors. We're here because of a clear exceeding of his power that we gave him, the parties gave him. The agreement just says submitted, the issue submitted. The agreement doesn't say ADA. So the parties submitted the ADA, and they also submitted, not guideposts, the law. Here are the elements by agreement. That makes this case different than what the defendant appellee is trying to tell you it's. So
Your time has expired at this
right.
point.
Well,
so.
we thank you for your time, and to the extent there's additional briefing, we'll definitely comply with your orders.
Yes, thank you. We'll get a jurisdictional order out shortly, and thanks to all counsel, the case is taken under advisement.
Thank you.
Our next case for argument this morning is Arias versus Garland.
It's okay.
Take your time. Not at all. Take your time. All right, Ms. Is it Chun?
Ton.
Ton.
Your Honor. Good morning, Your Honors. May it please the Court. My name is June Tun, and I represent the appellant, Ms. Carla Granados Arias, in her petition for review before this Court. The issue presented to this Court is whether the agency, the Board of Immigration Review, has honored the responsibility of review to which it has been entrusted to do so in reviewing Ms. Granados Arias' appeal of the immigration judge's decision denying her applications for asylum, withholding of removal, and protection under CAT. The answer is no. The record reflects that the Board neglected its duty of administrative review and ignored both Ms. Granados Arias' arguments and the evidence that was presented. Both this Court and the U.S. Supreme Court have sharply criticized the Board's negligence in executing its duty of administrative review. This circuit has a long-standing history of vacating BIA decisions where the agency has failed in its duty of administrative review by neglecting to examine the record and provide a reasoned explanation. Most recently, in Sanchez v. Sessions, the Court held where the Board concluded, but without explanation, that none of the evidence would have likely altered the outcome of this case with regard to the hardship that would accrue to his children.
If I could interrupt right on that point at the outset here, this is hardly an unexplained set of decisions from the Board of Immigration Appeals and the immigration judge. These are robust explanations, and I know you take issue with some of the conclusions that the agency reached in both of these decisions, and with some of the treatment of the record that the BIA and the IJ gave to the case, but it's not a case where there was a failure of explanation. There's a robust explanation in both decisions, so we can kind of skip to the next point. And the difficulty I'm having with your argument is that while you're quarreling with the agency's treatment of different sort of baskets of evidence here, you never really engage with the linchpin of the decision, which is that there's no nexus here between to a protected class or protected group.
So the protected groups that were articulated were four, and specifically two of the actual social groups that were proposed were not addressed in the immigration judge's decision, nor was it addressed in the BIA's decision. And that's where the judge then states that we don't get to the nexus, but I feel that the two social groups that were not explained in the decisions were that, exactly, and that women business owners in El Salvador who do not abide by the extortion efforts of the gangs and women in general in El Salvador connect to the nexus of what she has suffered. The past persecution is that
Ms. Hunt, forgive me, but what evidence was presented that the extortion was motivated by their status as business owners or women rather than perceived wealth? Is there any indication that if they were wealthy through some other means that the gangs would not target them?
Yes, Your Honor. The evidence itself was her testimony. And in her testimony, she stated that they received this note specifically requiring that the payment be made, drew a map of where the payment should be made, but also included that they should leave an intimate piece of undergarment. And I think that's what distinguishes it. It's not just the perceived wealth, but they have targeted women business owners. Had the note just mentioned, leave a certain sum of money at this location, it would be perceived wealth. But he took it a step further and requested that an intimate article of undergarment be left in addition to this money. In addition, the expert opinions also demonstrate that not only is there extortion by the gangs to all business owners, but women in general have been a marginalized group that has been historically throughout the culture of El Salvador. And this is where the board has failed to consider all the material and relevant evidence. This is in the regulations that it must consider all the relevant evidence. And I think that is the main crux of the argument, is that they have decided to ignore two of the proposed social groups and stated that they're not going to get to that because there is no nexus to the past persecution that she suffered. But the evidence does show that this is not just a regular case of extortion. The individual targeted Ms. Granados Arias and her sister because they were women business owners in El Salvador. And this is the main issue that I see here, is that although that there was an opinion, they did not consider the evidence that was material to the argument that was made. We have to go ahead and see that economic deprivation does rise to the level of persecutory harm. And in this case, she had to shutter her business after several months of successful business with her and her sister due to this threat that she received. And this threat is what caused her to stop her business and leave the United States. The government points to the fact that, well, there's no future harm because her sister is living a wonderful life now in El Salvador, but this is not the point. She has now have led to a fugitive life. She doesn't work anymore, and she's unable to provide for herself. This goes to the evidence that was submitted that women in El Salvador are a marginalized group. They have been abused repeatedly by their spouses. The government now has also perpetuated this abuse by not providing any protection to women, and specifically women business owners in El Salvador. And had the immigration judge or the Board of Immigration Review provided some type of explanation or well-reasoned determination that this actually wasn't the point here in Ms. Granados Arias' case, then the decision would have been a reasoned decision. But with a blanket dismissal of the particular social groups and not addressing the hundreds of pages that were submitted, but specifically the articles that were submitted for these proposed social groups, there was a violation of due process in Ms. Granados Arias' matter. Here, as I stated, Ms. Granados Arias suffered the loss of her business when she had to close it because she knew that she would not be able to continue meeting the gang's extortion demands, and she feared retribution for her not continuing to contribute to the gang's coffers. She also stated in the evidence that she had a friend who was also a female business owner that defied the gang's requests, did not pay the amount of money, and instead reported this incident to the authorities. Because of her report to the authorities, a couple weeks later, her son was killed. This woman was her friend. Karina also fled, and it's unknown where she's fled to, but this is a parallel example, and that Ms. Granados Arias could have had the same fate had she continued to keep her business, or had she went ahead and reported this to the authorities. And that's why I think that women business owners is a particular social group, and that there is a nexus with what she had suffered. She had to close this business because of this threat that she received. And the threat that she received is different from just a generalized threat. The immigration also, but even if Ms. Granados Arias has not experienced past persecution, the record evidence also establishes that Ms. Granados Arias had a well-founded risk of future persecution because of the observed prevalence of Salvadorian gang retaliation against those that have perceived to have defied them. There were several articles that describe the harm to business owners if or when they failed to comply with extortion demands. There were several articles that stated that persons who had resisted the authority of the local gang, or even just had inadvertently crossed it, are reportedly subject to swift and brutal retaliation from the gang. As low as a 10% chance of being shot, tortured, or otherwise persecuted is sufficient for establishing a well-founded fear of future persecution. While these articles were presented, none of these articles were discussed either by the immigration judge or the BIA in its decisions. Moreover, in finding that finding the absence of an objective risk of future persecution, the immigration judge incorrectly relies on the lack of harm to Ms. Granados Arias' sister and mother, who remain in El Salvador. However, her family members in El Salvador live a fugitive life. She testified.
Did you want to reserve some of your time for rebuttal?
Yes, Your Honor, I lost track of the time.
Okay,
Thank you.
Mr. Fulton.
Good morning, Your Honors, and may it please the Court. Today I plan to discuss 3 independently dispositive reasons that this Court should deny the petition for review. First, Ms. Granados failed to challenge the agency's dispositive nexus finding that the extortionist here was motivated by her perceived wealth. Second and third, the record does not compel a finding of the requisite nexus or an objectively reasonable future fear. I'd also like to explain briefly the adequacy of the Board's decision if the Court is interested. Now first, as to waiver, petitioner waived the nexus issue in her opening brief. Although she makes a conclusory assertion at one point that she did establish nexus, she doesn't advance an argument that the gang was motivated by anything but her perceived wealth. As I'll discuss shortly, the first element of this nexus requirement is a basic motive showing, as Your Honors have explained. Now, our brief pointed out the lack of...
If the status as a business owner or woman business owner causes the gangs to target them as a matter of course because they believe they can take a cut of the profits, isn't that, or would that be an action based on their membership in that group? And why should that be disregarded merely by saying it is based on their perceived wealth, in your view?
Well, Judge Rovner, what this nexus question asks is what motivated the harm, as you note. So under this Court's precedent and Board case law, what that question really means is, as this Court noted in Melnick, was there animus against this proposed group, or was it simply a means to an end? So to the extent that the gang used or looked at small business ownership as a mean to an end to obtain money, that does not meet the nexus requirement. I think we can also look at this Court's decision in Oriana Arias, where, as the agency relied on this case, that the gang's motive was to fill its coffers with money, and then that did not meet the nexus requirement. Put another way, but for the small business ownership, the gang still would have targeted Ms. Granados Arias because they perceived she had money. If the money, for example, came from another source, the gang did not care about the fact that she was a small business owner. It cared about the fact that she had money. Before explaining nexus in greater depth, I would like to briefly mention, as Chief Judge Sykes noted, nexus was a dispositive finding here, but that is a different question, and I think petitioner is kind of conflating these two issues. First, is a particular social group a legally cognizable basis for an individual to apply for asylum? That is a separate and antecedent issue to the nexus question, and so because, as the board said, it found nexus as a dispositive reason here, it did not need to address the cognizability question. So that's why the board didn't go into details as to whether it found these particular social groups viable. And I do think petitioner is conflating these efforts, and that's why she, for instance, waived these issues in her opening brief, because she relies too heavily on whether these groups are cognizable. As to nexus here, we know that the immigration judge was focused on the motive as perceived wealth because the agency specifically said so. In AR6, the agency said the gang was motivated by, quote, her perceived wealth so that the gang could raise money for its criminal ventures. In so finding, the immigration judge reasonably emphasized the $50 sum that was demanded by the threatening note. That's at AR89 where the IJ makes that finding. The immigration judge also relies on the fact that this risk of extortion is shared by other wealthy Salvadorians. That finding is also at AR89. And this factor, I'd like to note, emphasizes the way that the agency did consider the country conditions evidence, because it's looking at not only what happened in this specific case, but it's considering the evidence that small business owners are targeted or are extorted in a large group, rather. I think the country conditions evidence, one of the pieces that Ms. Granados says the agency overlooked is an article, for instance, that says a large percentage of these groups, of these individuals, small business owners, are extorted. So this really goes back to the point of what was motivating the gang. And the fact that they are targeting small business owners to get money from, that's simply a means to an end for its efforts to get money. This case is very similar to what the court found in Melnick, where it said that there was no animus towards small business owners. Again, this is a somewhat similar to a means to an end analysis, that means is not sufficient to show that its motive was actually money. Put a slightly different way, there's no intent to overcome the characteristic of small business ownership. All the gangs are trying to do is get money. That's exactly what this court said in Melnick. There's no nexus because, quote, the small business owners simply have money that the criminals want. Essentially, these individuals were a convenient target. I'd also like to briefly note the fact in petitioner's opening statement here today, she noted the fact that the note here mentioned an intimate undergarment. I'd like to first note that petitioner did not mention this piece of evidence in her closing statement in immigration court. She did not raise the motive issue on appeal to the board, so she essentially abandoned this piece of evidence, and that's one reason that the agency's focus was so much on her perceived wealth, because that's what her theory was throughout this course of the proceedings. But even if we are to look at that aspect of the note, the record does not compel a finding that gender was a motive in this case at all. And we can look at a couple pieces of evidence on that point. The first is the note that petitioner also mentioned to her friend Karina. Right around the same time that petitioner and her sister received a threatening note, her friend Karina also received a note demanding a $50 sum. That note, there's no indication of any evidence that note mentioned intimate undergarments or anything about gender, even though Karina was a female small business owner. What she had was money. That's what the gang really wanted. We can again look to the fact that the IJ emphasized that the country conditions evidence shows that small business owners are extorted en masse. That also shows that gender is not what the gang cared about. It simply wanted money. So I'd like to, with my brief time remaining, I don't want to belabor this point because, as Chief Judge Sykes noted, the agency decisions here are robust and detailed. But just a couple quick points. The board itself does discuss country conditions evidence at AR7, and at AR8 it devotes one of its last paragraphs to confirming that the immigration judge analyzed the documentary evidence in this case. That's at AR8. If we look at the IJ's decision itself, The immigration judge at AR 84 says it's considering the following evidence in its decision, and then it cited the exhibits, including country conditions exhibits. The immigration judge in its decision also explicitly cites Exhibits 6 and 7, which are expert reports and country conditions articles. That's at AR 91. And again, the immigration judge's nexus analysis specifically discusses that this extortion risk was shared by other Salvadorians perceived as wealthy. That also reflects an analysis of country conditions evidence. Of course, there's no need for the agency to cite specific individual news articles in its decision, particularly whereas here the applicant submitted well over 100 pages worth of documents of country conditions evidence, and she did not in those documents highlight specific pieces that it was relying on, which is what the Immigration Court Practice Manual requires. Now, briefly, Your Honors, I'd like to explain this last factor. The record does not compel a finding that there was an objectively reasonable here. Again, this is an alternately dispositive basis on which this court could deny the petition for review. So even if this court were to overlook petitioner's waiver of nexus, and even if it were to disagree as to the no nexus finding here, it can and should still affirm or deny the petition for review for lack of an objectively reasonable fear. So in this case, a record does not compel a finding of this fear. There was only one threat back in 2014, and neither sister who opened this tortilla business has been threatened once again. What's significant here is that these sisters are similarly situated. So while the petitioner fled to the United States, her sister remained in El Salvador and only moved a few houses down, and the fact that she chose not to work does not in and of itself establish that she is a fugitive. The board explicitly considered and rejected that requirement, or that argument. I see that my time has expired, Your Honors, so unless there are any other questions, I'd like to rest on our brief for any remaining issues and ask that this court deny the petition for review.
Thank you very much.
Thank you.
Ms. Chun, you had 18 seconds left. I'll give you an extra minute to give us some rebuttal.
Thank you, Your Honor. Just really quickly, I'd like to distinguish, as opposing counsel stated, that Melnyk does not fall in line with Ms. Granados Arias. In Melnyk, it was a husband and wife who were from Ukraine that also had a business and were extorted from their business. In this case, they specifically targeted Ms. Granados Arias because she's a woman business owner. That's why this case does not fall in line with Melnyk. It's clear that the immigration judge cited to the country reports, but she did not provide any meaningful explanation and only stated that these generalized economic disadvantages and conditions facing the entire populations is not persecution, without discussing any facts that were related to her actual case. Ms. Granados Arias' economic hardship is unique to her in the fact that she was a business owner that was female. The generalized country reports that she reports to discusses not only the harm that women face in El Salvador, but also business owners. And for this reason, we request that this court remand the decision and to give Ms. Granados Arias an opportunity to have her case being meaningfully discussed and reasoned. Thank you, Your Honors.
Thank you. Our thanks to both counsel. The case is taken under advisement. Our last case for argument this morning is the United States against Tan. Whenever you're ready, Mr. Steinbach.
Good morning, Your Honors.
Good morning.
May it please the court. I want to begin with a little personal note. I don't feel old, but My hearing is evidently getting a little old. I know this because my grandchildren throw toys at my head because the volume of the TV is so loud they can't hear and it hurts their ears. So if I'm looking peculiar at someone and can't hear what's being said, you'll know why.
Mr. Steinbeck, before you even begin, let me just mention something, please, because you raised an ineffective assistance of counsel claim. And, you know, we've held so really repeatedly that even meritorious ineffective assistance claims are likely to fail if raised on direct appeal, because of course there's no opportunity for the development of evidence. Would you want to withdraw that claim now and preserve the opportunity for Mr. Tam to present it at the more, at a more proper time?
Your Honor has anticipated me precisely. Looking at the government's argument and reviewing our argument, I think it's premature. I would ask the court to allow us to withdraw it without prejudice.
Sure.
Thank you.
Thank you.
Your Honors, the problem with this case is fundamental. The defendant was never asked questions critical to any fundamentally fair sentencing hearing. He was never asked if he read the pre-sentence report or the supplemental report, if he reviewed it personally, and if he looked at any and all of the items that were contained therein and found any errors.
What are the answers to those questions? Did he read it?
No, he did not read it. He never even saw it. I spoke with him. He didn't know what I was talking about. I described it to him. I know about these things for 45, 48 years. He couldn't understand what I was referring to. And it became painfully clear to me that this needed to be an issue raised.
Why didn't you assert that in your brief? There's nothing in your brief that says that.
The reason I did not do that is because I don't know how to resurrect a record where no one asked the question that needs to be asked. If I'm constrained to the record below, it's silent, and it's silent for the very reason that the court failed to ask the question.
Well, we have a confession of error here from the government that there was a failure on the part of the district judge to directly question the defendant about whether he had reviewed the pre-sentence, had done so with his attorney, and to ask him if he had any corrections or objections. But that just begs the question about what the answers to those questions would have been had they been posed to him, and you never stated in your brief that he did not read the pre-sentence, he did not review it with his counsel, and that he did have objections and corrections to make. And you did not identify any objections or corrections that he wishes to make were this case remanded. And so that's a failure on your part that makes the error harmless. And there's also a concern, which is that it conflicts with what his attorney said on the record, which was that he did review the pre-sentence with his client, and that there were no objections other than the one that was the objections that were preserved in the sentencing memorandum.
Precisely, he said on page 4 of the transcript, I have read those and I reviewed them with my client, and I don't have any objections. Never once was the defendant brought into this, and since Your Honor is asking the questions, among the many, many other questions, other answers, there are these two. The defendant didn't just get replaced as suggested in the facts in the pre-sentence report. He voluntarily withdrew almost 5 years before this case was ever brought. And
that has something to do with the role in the offense reduction that was in fact preserved and argued. My question goes to what objections does your client have to the pre-sentence?
It's not in there. The pre-sentence report.
I'm asking you now, does he have any objections to the pre-sentence that he would have raised at the time of sentencing with Judge Kendall had she asked him directly if he had reviewed it and had any corrections?
One, he objected to the failure to include, and it's also not just what's in there, but what's incomplete. The failure to include the mitigating circumstance that he wasn't replaced, he withdrew as a courier on his own volition, walked away for all the right reasons. And he didn't get into this, which is another factor which would have been important, at least under 3553A, because of greed. It was desperation.
No,
And
I'm
it-
talking about corrections to the pre-sentence report, not what arguments he would have made on the 3553A factors. I'm talking about objections to the pre-sentence or errors in the pre-sentence, because that's your argument, that he wasn't directly asked about that.
The pre-sentence report is incomplete, Your Honor. It fails to include those items, and part of the inquiry is not just whether it's accurate, but whether it's complete. And how is it that a court is expected to determine the accuracy of a pre-sentence report, which is the cornerstone of any federal sentencing, without asking the defendant himself if it's complete? It's not. In addition to that, there is a statement that he was a social drinker. Well, perhaps at the time he was asked that question by the probation officer, he was a social drinker. By the time he came to sentencing, he was a problem drinker, a trouble drinker. And it is important to have that correction made, because not only...
Okay, all of this is new at oral argument. None of this was in your brief.
How am I supposed to bring into my brief things that aren't in the record below? How do I do that? Am I free to
You have
just...
to identify the ways in which the error that you're claiming is harmful. And you didn't do that. You just asserted error, and there's no discussion of how it harmed your client.
Doesn't the Seventh Circuit's case that the government relies so heavily on, this Rodriguez-Luna case, talk about the fact that the failure to do this is nothing short of despicable or something that shouldn't ever be done? And what has happened here is the burden which Rule 32 places on a district judge to ask questions of the defendant, which is mandatory, must, not may, must, has been reversed now, and is incumbent, according to what Your Honor is saying and what the government is asking, on the defendant to come forward with those things without ever having been asked.
This is just ordinary harmless error review. There's nothing extraordinary going on here.
I'm sorry?
This is just ordinary harmless error review. There's no burden shifting going on here. There's nothing unjust about these questions.
There's nothing unjust about saying that the defendant himself did not bring these up when he was never asked?
No, I'm talking about how you briefed the case, counsel.
Well,
you didn't tell us any of what you're telling us now in your brief. So all of these arguments that you're making now are waived.
Well, I hope Your Honor will listen to them in the context of the fact that no sentencing should go forward risking, as this case did, the prospect that many, many important facts were never known because of the simple expediency but mandatory nature of the inquiry, which was failed to be made. And the fact that this can ever be regarded as simultaneously despicable and yet at the same time excusable befuddles me. And it's a dangerous precedent, because every court will now say to themselves, I don't have to go into this. We can infer it. Would this panel say to me at a change of plea hearing under Rule 11, you don't have to ask the defendant if he's pleading voluntarily. I'll tell you he's pleading voluntarily. I spoke with him. I know it. So you don't have to go into that. Every sentencing judge would say, excuse me, Mr. Steinbeck, but that is a question I must ask the defendant directly. Is there something less important about a sentencing proceeding than a change of plea proceeding under Rule 11? Rule 32 is just as mandatory, requires just as much specificity, and the court failed to do so, and in failing to do so, gave rise to all of the problems which Your Honors are now saying I've waived, but in fact, there is no opportunity for me to have ever gotten into without resurrecting a record that has already been complete long before I ever got into this case. I ask that this court carefully consider the danger in allowing this to continue and allowing any district court to just pass over a mandatory obligation to inquire not just of the defense attorney, but of the defendant himself to make sure the defense attorney didn't misunderstand what he was talking about with the defendant or didn't misrepresent it. It's not the first time it would have happened. I doubt it'll be the last, and I can assure this court that the sentencing was predicated on incomplete and inaccurate factors, and I hope that the court will reverse and remand for resentencing. Thank you.
Thank you. Mr. Shi?
Yes, good morning. May it please the court. My name is Jonathan Shi, representing the United States. This court should affirm Mr. Tam's sentence. With respect to the Rule 32 issue, the record below indicates, at least the record below prior to oral argument indicates that the defendant did in fact have the opportunity to review and did in fact review the PSR, and that there were no unresolved sentencing issues that were not brought to the district court's attention. I think the best evidence that the defendant did review the PSR is the statement by his attorney indicating that I have reviewed both reports with my client and there are no factual changes. So his statement is not that, the defense attorney's statement is not that he himself reviewed it, but that he and his client, Mr. Tam, in fact reviewed the PSR. The defendant was present when that statement was made. This was an in-person sentencing in front of the district court. And the defendant did not contradict that statement or raise any concerns about that at the time.
You know, the court at sentencing identified the factors for a minor participant adjustment, but the court never discusses the facts supporting each factor, instead merely rejecting it based on the facts as set forth by the government. Do you view that as a sufficient analysis?
Thank you, Your Honor. Yes, I do. And I would point to the cases cited in our brief, in particular, the Seventh Circuit case in Campuzano Benitez, that the district court does not need to go through a checklist of each of the 3B1.2 factors and make an independent evaluation of each of those factors one by one. Instead, the court can take a holistic view of all the factors and make a determination whether the minor role reduction is appropriate in that particular case. And I would submit that in this case, the court properly weighed those factors and correctly determined that the defendant was not entitled to that minor role reduction. There is, the defense has cited some Ninth Circuit cases as well regarding that particular issue, but even those cases recognize that there is no technical requirement for the district court to actually go through each of those individual factors. In addition, there is no indication in this case that the district court was unaware of the factors, and in fact, the district court laid those out during the sentencing hearing itself, and then weighing those factors concluded that the defendant was not entitled to that minor role reduction. Just briefly, Your Honors, returning to the Rule 32 issue, with respect to two of the new issues that have been brought in oral argument today. As Your Honors have pointed out, those arguments are waived at this point. But even if you were to consider the merits of them, one of the key factors that the defense is pointing to is the failure to, object to the fact that the defendant voluntarily withdrew from the conspiracy. That was not a contested fact at the sentencing. And in fact, the defense attorney raised that as an issue in mitigation on pages 14 and 15 of the sentencing hearing transcript. And so we would the government would argue that any error committed by the district court in not specifically confirming with the defendant that he had reviewed the PSR is harmless, and that's consistent with Jaragisi and the other cases cited in our brief. And unless the court has any further questions, I would ask that you affirm Mr. Tam's sentence. Thank you.
All right, thank you very much. Mr. Steinbeck, your time had expired, so we'll take the case under advisement, and that concludes the calendar for today. The court is in recess.
Thank you.